This is the first episode of Atticus Defends. We're really excited to bring this to you. My name is Ali. I'm the CEO of Jurist AI. I have with me my Chief Legal Officer, Mark, and my Chief Revenue Officer, Dakota. What we're going to be doing in this series is going over some popular cases and trying to reimagine history. What if the defense attorneys on those cases had access to the wonders of the modern age, technology like AI, and specifically a tool that we've developed just for this use case called Atticus? Mark, do you want to introduce yourself and talk a little bit about your background?
Mark Underwood. I am the Chief Legal Officer for Jurist AI. I am an attorney of 35 plus years experience. I started off actually with a federal contract doing US 1983 cases. I have primarily been engaged with not transactional necessarily, but IP and technology law throughout my career, and was a litigator at the outset of my career. So that's my background in terms of how I will approach the way that we look at some of these historical cases.
Awesome. Thank you. Dakota, do you want to talk a little bit about yourself?
Yeah, Dakota Gum here. We've worked for the past 4 to 5 years now in the AI technical space. Saw what Jurist AI had going on over here and wanted to help just bring ease of access in the legal space to the masses.
Awesome. So Atticus is litigation lifecycle software. So we'll show you what it does and what it's capable of bringing to legal cases. But first, we want to talk a little bit about the Martha Stewart case. So I don't know much about this case. To be honest with you, I know it's kind of everywhere, and there was a documentary recently. I know Mark and Dakota are pretty familiar with it. Mark, do you want to kind of set the background? Who is Martha Stewart, and where is she in her life before this indictment hits her?
Martha Stewart is quite an interesting character, and I'm rather contemporary with her because I was practicing law when this was all happening. For those of you who don't know, Martha Stewart is the homemaker's guide to pretty much everything. She had an elegant style. She was the uh, creator of Martha Stewart Living. She was Time Warner's essentially first foray into doing a magazine that was strictly meant to be a style type magazine for homemakers. She went on to spin this out to her own company, which she built into something that we would all know today as an omni-channel. She was literally a media mogul at the time. She took her portfolio of products that she had spun out to Kmart, which was fantastic. That was a huge spin into the market space. So she hit every sort of demographic in the market space at the time. She then took her company public, which was incredible because she was the first female CEO to do that. And she became the first female billionaire, which was
Wow.
incredible at the time. She was quite the dynamo, frankly, and
So
I
she was the
admire
first
her very much.
female billionaire ever,
Correct.
and she got taken down, which is very interesting.
Well, she apparently made some enemies along the way. That happens with smart people. I think it happens with smart women more often than we would care to probably discuss. So she was a target, I think, and that's my sort of opinion on it. I had the great good fortune of stumbling across the relatively new on Netflix documentary that sort of talked about how she grew up, how she became the person that she was, how she became the CEO of a very major corporation, and how she spun that into an IPO and then was taken down by the federal government. So it was quite a journey. I was incensed by some of the things that they did because she was a public figure. And frankly, I brought this, I think, to you guys to talk about how she was defended, how the case was brought against her, and some of the ways that we could take a look at that now and see how Jurist AI and Atticus could take a swag at this essentially and see how we may have helped in some of the arguments that maybe were not highlighted by the defense at the time.
Yeah,
And
seems like
one
a good
thing,
thing.
one thing you had touched on, Mark, that I want to touch on briefly, Ali. Apologies. Uh, Martha Stewart, you say that she's had a target on her back. This is something that we've seen repeated time and time again. This wasn't just after allegations were made of inside trading and everything else that we'll get into. But I remember seeing her in an interview. I can't remember what channel she was speaking with, but even just getting flack for having her products in Kmart because Kmart wasn't this high-end, super luxury store. And she was standing very firmly on the fact that she's looking to bring what she has to everybody and not just make it a one of one for a special, class of people in the hierarchy. So I think it's important to touch on that is she's always had a target on her back. It wasn't just because of these allegations. And I think, like you mentioned earlier, a lot of it boiled down to maybe a little bit of jealousy for having, such a smart woman that's really just taking off in, a space that hadn't been really created yet, especially for the homemakers. So just wanted to touch on that briefly.
So it
Yeah, she
seems
was
like Martha
definitely.
Stewart was one of the first mainstream homemaking influencers, but she also was able to spin that off and build an empire out of it. And along the way, made enemies, which anybody that becomes successful does that, but got taken out. And I think a lot of people have a lot of skepticism with the legal system. We know that federal conviction rates are at 97%. So when somebody is indicted by the federal system, at least, there's very little chance that they can get out of it, even if they are innocent or even if the charges are capricious. And a lot of
This whole thing was Martha Stewart was brought because she was a public figure. Uh, she was charged with insider trading. All right.
Mhm.
Part of what insider trading includes is three things really. There's an intent, just like in any case that's brought. There is the actual factual sorts of things that happened, and then there's the procedural part of the whole thing. So
Okay.
there were a couple of things that were totally ludicrous in this entire case. First and foremost was SEC and FTC are how this whole thing would be guided, right? So you have the Federal Trade Commission, you have the Securities and Exchange Commission. Under the Securities and Exchange Act of 1934, there are provisions and laws that are enforced through the SEC and FTC that build the framework for how we maintain some modicum, some sourcing for how securities are exchanged across these various trade boards. Now that's where we run into challenges with Bitcoin and some of the other things which are sort of outside the discussion point here. But there's a legal framework for the charges that are brought in one of these things. And so one of the impacts that was here was they brought an insider trading case, but there was no claim of actual insider trading, right? Second, they claimed securities fraud. And third, they claimed a cover up. One of the things that she used when she was first approached by the government in this case was, and she was advised by her attorneys to do this, and that was if they ask you a question and you don't have the complete details of it, tell them that you don't remember. And that
Yeah,
was a bad
which is
set of
common.
yeah, it's just a bad it's just a bad advice. You tell what you know and that's it. That's all you need to do. If she had done that, if she had said, listen, I got a phone call, here's what the facts were, here's what happened, I think it would have been at least a better appeal case for her later on.
Yeah.
So let's talk about this. Which one do you want to talk about first? Because the cover up charges, the fraud charges, the lack of bringing an insider trading.
So it
Yeah, she
seems
was
like Martha
definitely.
Stewart was one of the first mainstream homemaking influencers, but she also was able to spin that off and build an empire out of it. And along the way, made enemies, which anybody that becomes successful does that, but got taken out. And I think a lot of people have a lot of skepticism with the legal system. We know that federal conviction rates are at 97%. So when somebody is indicted by the federal system, at least, there's very little chance that they can get out of it, even if they are innocent or even if the charges are capricious. And a lot of that has to do with the fact that the federal government has infinite resources and infinite determination when they accuse somebody to try to put them in jail, but oftentimes defendants don't. So that brings us to Atticus, which we built to address some of those inequities. We've got AI, which is incredible, and we've got all these software tools, but they're being underutilized in the law. So let's take a look at the Martha Stewart case using this new technology and using a seasoned attorney's knowledge and expertise like Mark, so that we can see, hey, what could modern technology bring to the conversation? So let me just log in here real quick.
And while you're doing that, I just wanted to sort of follow on with comments that both you, Dakota, made and Ali made as well. I think one of the things that we see, especially in the United States, is when someone's successful, you'll root for them on their way up. But when they get to the top and you see that success, there's a tendency in the I want to say zeitgeist in the world at large, in the social communities, to say what you said, which was jealousy, and then the climb to the top, which is arduous typically, and then the fall from the precipice. It's very much people like that. There's an entertainment value that I find a little disturbing, but we've seen it happen time and again. And I think this is just one way that we can sort of highlight how Atticus would generate some of the defense arguments that were brought in this case.
Great point. So one of the first things I noticed when we're looking at this particular docket, which is Martha Stewart and Peter Baknovic, I think I'm pronouncing that right. Peter Baknovic, I saw, had appeared as her attorney. So how did he end up on the indictment here?
That's sort of a mystery. I look back on that. I don't know if it was because of the context with which he was an attorney for her. I think he wasn't her attorney. I think more so he was her broker, and he's the one that had made the phone call. So I think they were using that as the basis for the insider trading, if that makes sense. So I think I'm not certain where you had read where he was one of her attorneys. I think he was her broker. He's the one that made the phone call. She didn't have a direct phone call, say from ImClone's original founder, with whom she had a personal relationship.
Yeah, you're right. He was her broker. You're right. But he had appeared on somewhere. I guess he had must have made a testimony before he was indicted as part of the case. I think that's what I was seeing. Either that or I could be misremembering it. So let's just kind of look at the docket. So she gets indicted June 5th of 2003. This is a lengthy case. I mean, this case, there's a whole bunch of filings. It doesn't look like it actually ends until about 2010. The docket is just massive. Why is it sometimes it seems that some cases tend to be very short and then other ones like this are very drawn out, from your experience as a lawyer?
Well, you have to sort of step back and see how this case sort of unfolded. So she made the decision after a phone call from her broker on December 27th of 2001. So after that happened, she sort of let it go and went on with her business. In the background, there was already some challenges with the company Imgen to begin with. They were already, I believe, under investigation. And so
what is Imogen? Imgen or Imogen? What is that exactly?
Imgen is a company. Hang on, let me pull that up.
They created like a cancer curing drug that wasn't approved by the FDA, I thought.
Yeah, I think they were in the middle of FDA approval on a cancer drug. They were on the climb for their trials. Post-trial, they realized that they were not going to get FDA approval, and so some of the hierarchy within Imgen started selling off their shares ahead of that announcement.
Interesting. It looks like the company is still open. If it's Inogen,
No,
ImClone.
Imgen.
something clone, ImClone. Okay, all right, here we go. ImClone, Martha. So they had a cure or they had some kind of treatment for cancer that was not FDA approved. Were they still doing
there was a
research on it?
process of it. When they found out they weren't going to get FDA approval, that's when the whole insider trading, they sold their stock, knowing that it was going to take.
I see. So this is where the accusations stem from.
Correct. And so for factual rules, one of the things that came up and was brought up was that she had her broker, which we just discussed. She, like many people who invest, had a pre-existing agreement to sell stock at any given time. So when they brought these sorts of things, that was one of the affirmative defenses, and that's why I think they brought the case against Backnebeck as well. Was because he's the one that knew that there was a pre-existing agreement to sell. He's the one that made the phone call. She said, as I understand it, based on some of the historical docuseries that was done, he's the one that made the recommendation that she sell.
Interesting. So is it legal to have an agreement like that? So what was the agreement to sell based off of?
Very common. Very common.
But it
They were
can't
gonna
have
sell.
off of the stock crashing, could it?
Say that again, Ali.
So if they have an agreement to sell, what was the clause or the trigger for that? Because if you sell something, if you sell a security because you know that it's going to crash beforehand, that's insider trading. So what was the clause or the trigger that, from your perspective, made this a legitimate agreement to have?
She already had this pre-existing agreement. This is very typical when you have a broker working for you. The broker, in this case, called her up. And I think that's the whole crux of what happened. He called her and said, hey, this is whatever their conversation was. Do you want to sell? And she said yes. It was very offhand. As I read this was a very typical thing. A broker back in the day would call you up and say, hey, I think you should sell Imgen. There's a pre-existing agreement to sell. All I need is your approval. She said, yep, hung up. That was it. So,
okay, so they had already drafted up this agreement. It's just that he had called her to execute it because of something that he had learned.
that's correct.
But the agreement was already there.
Say that again?
But the agreement was already there.
Yeah, it was. That's why when you look at this case of insider trading, she was never charged with insider trading.
Interesting.
Which is I think, one of the key elements here that the federal government in this case used against her because of her social status, because of her celebrity. And so that was something that came out later. When you start looking at the actual facts of the case, it's pretty overwhelmingly and kind of disgustingly, to your point, Ali, the federal government with its weight behind it, basically hammered on the fact that she was lying the whole time, when in fact, all they could point to was her resultant sort of pre-testimony when they took her statement that she didn't recall all of the events around this. And that was, of course, based on her legal counsel's advice. I think if she may have stood her ground and said, look, all I got was a phone call from Backnebeck, that may have helped her a great deal. And I think that's one of the things we can talk about as we move through the case.
For sure.
And
Yeah.
one thing that would be interesting to see as well is how many other people sold around the same time as her, because their agreement was in place that they would sell once the stock price dropped under $60. And this information that Peter had brought to her came from Sam Wackall, however you say his last name. He's the CEO of Imclone, but he was the one who started this and triggered this all by dumping his own stock. So how many other people had that kind of information and knew that and went and sold their shares off as well? Now, were they sitting there facing prosecution? You know, like, those are the kind of questions that come to my mind. Was Martha Stewart the only one out of the group of however many people that were probably selling at the same time as her? Was she the only one that dealt with repercussions from it?
So again, you have to sort of look at it historically, right? At the time, George W. Bush was president. There were some challenges to how the market was actually working at the time. There were some financial pressures that the federal government was under. And frankly, when you have a case like this, it's not as sexy when you're going after Waskell and Imclone, right? It's sexier to go after the big celebrity who owned 4,000, how many shares of stock did she own? Somewhere in the neighborhood of $45,000 worth, I want to say. Hang on, let me pull that up. She owned 4,000 shares of this, and she was only facing approximately $45,000 worth of loss. So that should tell you a little bit of something right there. She's a billionaire. Her company's worth.
That she sold about $230,000 of shares after
but
The
she was only
CEO's
facing
daughter had
$35,000 of loss.
so the CEO's daughter had before Martha Stewart had sold 2.5 million. Her father, the CEO, had sold 8.1 million. The other executives followed suit. The general counsel, the attorney for the company, sold 25 million. And then Ronald A. Martell sold 2.1 million about a week before that. Then she actually sold the smallest amount. And then you said the loss would have only been about $5,000 based on,
$45,000 total to her.
yeah, which is nothing to her. That's like a four and a
That
half.
was part of the defense that wasn't really, I think, hammered to the degree that it should have been, was what was the huge loss to her? She's worth $1 billion. She's a billionaire. $45,000. The intent portion of this case was the weakest part of this whole thing.
Mhm.
But again, to Coda's point, I think it really boils down to she was the sort of poster child that they wanted to bring down, and what the prosecution kept hammering was that she lied. So it was really the obstruction of justice charge that boiled down to the bottom line for the case.
So she gets indicted. She makes her initial appearance. She ends up pleading not guilty about a week or two later. And then there's all of this litigation that happens in the middle here. We
And
see that,
highly publicized. Prosecution was in front of the cameras nearly every day, hammering on the fact that her statement, as advised by attorneys, said that she didn't remember things, and really it boiled down to the one phone call.
yeah, I see the amount of publicity that this got actually seems to have affected the trajectory of the case as well. I remember
Absolutely so.
making a comment about that. So we can see that there's all these motion by Martha Stewart and Peter Baknovic to strike inflammatory, prejudicial, and irrelevant surplusage from the indictment, um, memorandums to dismiss, affidavits. Let's go ahead and just take a look at the summary that Atticus produced for the case. So what Atticus does is it takes all of the case documents and it structures them according to when they were filed, and it analyzes the entire case history along with the docket, and it provides you with summaries and strategic suggestions based off of where you are in the case. And that includes the summary of the entire case, but also summaries of individual documents and then recommendations for what you might want to consider filing next. So let's just read this. The case of Martha Stewart and Peter Baknovic is being heard in the Southern District of New York, overseen by Judge Miriam Goldman Cedarbaum under this criminal number. Both defendants, Martha Stewart and Peter Baknovic, are represented by attorneys Robert G. Morvillo, John J. Teague Jr., and Richard M. Strasberg, with the prosecution led by Assistant United States Attorneys Karen Patton Seymour, Michael S. Shatter, and William A. Burke. Martha Stewart, a renowned public figure and founder of Martha Stewart Living Omni Media, and her former broker, Peter Baknovic, are accused of a conspiracy charge alongside related counts. Let me just open up the laser pointer here. Relating counts including securities fraud, obstruction of justice, and false statements to federal investigators. I see that there's no insider trading there. Specifically, the allegations pivot on Stewart's alleged insider trading and subsequent actions to conceal evidence about the sale of ImClone Systems stock back in December of 2001. These charges arose in the wake of news about negative FDA findings concerning ImClone's cancer treatment, Eridibux, which was made publicly shortly after Stewart's sale of stocks. The case does not directly charge Stewart with insider trading, but focuses on the alleged scheme to cover up the true nature of her stock sale and misleading investigatory bodies. Baknovic is similarly charged with aiding in this concealment and false statements pertinent to the precise timeline of trading instructions given to his assistant, Douglas Faneuil. Over the course of the trial, numerous complex legal maneuvers on both sides have unfolded. The prosecution has mounted a case based on communication records, falsified documents, and statements from cooperating witnesses, including Faneuil. Letters by the prosecution sought to mitigate arguments on motives for prosecution and downplay the absence of direct insider trading charges. The defense has been no less active, offering multiple motions in, how do you say this again? Lemon? You're muted, Mark. You're muted. You're muted, so I can't hear you say Lamin. Lamine.
Lemony, sorry.
Lemony. Yeah,
Just the kid.
Lemony. Yeah, I remember that now because that's got to be the best possible pronunciation of all possible pronunciations. Lemony. To exclude specific testimonies and seeking acquittal on several grounds, appealing to procedural issues and perceived unfair prejudices exhibited by the prosecution. Strategically, the defense could benefit from addressing the following three areas. So this is one of the things that Atticus does, is it looks at everything and it recommends a solution. So there was a recent study actually about doctors that were using AI to treat their patients, and they saw that when doctors used AI, it increased their accuracy about 3%. Now, the accuracy of the AI model on its own without the human input was above 90% in the study that I saw. So actually, it showed that there were some biases that the doctors weren't even taking into account. And even when using the AI, they weren't taking a look at. So there may be a significant paradigm shift where we look at these AI tools as providing a lot more support strategically, especially when we start using neural networks and statistics to help us make our decisions.
We have a software that is able to take in the docket, analyze the docket using our algorithm, produce a summary, and then based on that summary, make recommendations on the next steps in the case. I think that's the approach to take rather than highlighting the AI portion of it. I think the statistic that you just mentioned is very important because I think it shows the human plus algorithm way that this should be approached. Does that make sense to you guys?
Exactly. Yeah, so
I
it's
think part of this is
technology.
that AI is out there and AI is getting some of the thing, but we really have to the top of this call, to the top of this recording, we have a life cycle management of the litigation software.
Yes,
Make sense to you
exactly.
guys?
Yeah.
Exactly. So it supports you in every aspect of your main job function. So let's look at the recommendations that Atticus has, and then Mark, with his over 30 years of experience in the law, can give us some feedback on it. So Atticus says, first, a keen focus should remain on demonstrating lack of explicit intent or knowledge on Stewart's part regarding the transaction's legal breaches, emphasizing her trust in Bakovic's financial advisement.
What we're trying to do here is show that we have a software that is able to take in the docket, analyze the docket using our algorithm, produce a summary, and then based on that summary, make recommendations on the next steps in the case. I think that's the approach to take rather than.
Yeah, so it's
I think part of this
technology.
is that AI is out there and AI is getting some of the thing, but we really have to the top of this call, to the top of this recording, we have a life cycle management of the litigation software.
Yes,
Make sense,
exactly.
you guys?
Yeah.
Exactly. So it supports you in every aspect of your main job function. So let's look at the recommendations that Atticus has, and then Mark, with his over 30 years of experience in the law, can give us some feedback on it. So Atticus says, first, a keen focus should remain on demonstrating lack of explicit intent or knowledge on Stewart's part regarding the transaction's legal breaches, emphasizing her trust in Bakovic's financial advisement. Secondly, any inconsistencies or discrepancies in the witness testimonies, particularly related to Douglas Faneuil, should be meticulously dissected to cast doubt on the credibility of pivotal prosecutorial evidence. Lastly, considering the media's extensive coverage, it would be prudent to frame future motions and statements toward maintaining the jury's impartial view, highlighting the procedural missteps by the prosecution, or leveraging public sentiment to emphasize unfair treatment due to Stewart's celebrity status. In summary, this high-profile case weaves through the intricate themes of fiduciary duties, legal propriety in trading procedures, and the broader clamor of judicial spectacle within the securities domain, continually testing the agility and resilience of both defense and prosecution in the courtroom stage. So what do you think, Mark?
I think it hits it on its highest levels. So one of the things that I think is very accurate here is, first and foremost, not just the media extent, the extent of the media coverage and how that inflamed the jury potentially, but looking specifically at the prosecutorial reach here, and overreach in my opinion, because she was never charged with insider trading. And so that's highlighted in this summary. Attacking Fenuel, who they brought as a witness, I think he was a clerk or was doing secondary work. He never had direct contact with her for the call that they would use for the crux of the case. So I think as an overarching summary, this was just fantastically done. The biggest thing I think that may have been missed was this, what we discussed a little bit earlier on this, was the lack of financial motive, and hopefully we can get into that as well.
Ollie, your mic's muted.
So when you say lack of financial motive, can you expound on that a little bit?
Well, there's something called a motive and opportunity test. In some jurisdictions, courts use what's called motive and opportunity to evaluate scienter, which is the concept of demonstrating a clear financial intent. Now, if you look back at what we talked about when you pulled up that wiki for this, you saw all the number of shares there from the M-clone people. Mm-hmm. They had clear financial motive. When you look at the potential loss that Stewart had in this case, that was the big loss that the defense perhaps should have looked at, was only $45,000 plus or minus, right? The rest and the numbers of shares were just not really managed. And there are other cases that talk about this. There was Apple Computers. There are numbers of security cases that are representative of how this is applied. And this goes to the prosecutorial sort of approach here, that she's a public figure. We're going to hammer on the case that she's a liar, and everyone will forget that we really didn't bring anything of substance in the charges that we had. And that's really my whole the reason I'm so incensed about this is that there was nothing here of substance to put her in jail, and she ended up in jail. And I think that goes back to your social justice discussion at the top of our cast.
Yeah, one of the interesting things about the way that the legal system is set up in the United States is that there really isn't a lot of supervision or review or control over the whole prosecutorial system. So prosecutors basically are measured based off of their conviction rates. That's kind of what determines their job security, and also how high profile and how difficult the cases they win are. But when you have a system where the judge works for the government, the prosecutor works for the government, every federal attorney technically also has to be an employee of the federal government, then a defendant like Martha Stewart gets in the courtroom, and really she's the only one that's not working for the federal government. So it's not surprising that without some kind of a supervisory body, the conviction rates are so high. And that goes to your point, is how is it being determined who should get charged and not get charged according to, and then that goes to what Dakota was talking about earlier. It can really just be based off of whatever the prosecutor feels like. And I think a lot of people nowadays have and there's a lot of research on this, they have such a deep-seated mistrust of the legal system because it's inaccessible to them. And that's exactly what Atticus and Jersey AI's other products are trying to address, is that inaccessibility. If we have this product here, the solution really, that can go and look at the entire case and provide these strategic summaries that someone like Mark can say, hey, look, this is pretty good. I can use this to do my job. Then this helps us start shifting those scales or those balances so that the justice system and the legal system can start working better for everybody involved. So Mark, if you were an attorney representing Martha Stewart and you got these strategic suggestions, and then you also have your own ideas about how you'd approach the case, how would you do it? Because we see Atticus here, he makes recommendations: dismiss indictment due to prosecutorial abuse of grand jury process, dismiss count of indictment for defective statement. We've got some other ones that people can select. And then we can also go over here and just talk to Atticus and get some insights, whether about trial or profiling somebody. So what would you do if you were...
First two that you mentioned, Lee, are the ones that I would approach specifically, because with the indictment itself, the arguments with those two particular motions, I think, would be most relevant. And that would be, she had a pre-existing agreement, so that is a relevant motion. There was a lack of material misrepresentation. So, and these were actually argued in the case, but I think the suggestions that Atticus came up with are directly related to the way that the defense approached this. And there are a couple of other things that are a little may or may not have been relevant at the time just because of the publicity. The third thing was there was an absence of intent to obstruct justice. And as we talked about earlier, one of the suggestions for the motion would include the fact that there was no actual insider trading alleged in the indictment. So if this was truly an insider trading case, why was it brought at all? Does that make sense? So from the motion,
it seems like your first kind of argument is that there's an absence of insider trading. So let's talk a little bit about that.
Okay, I did. So what do you want me to say now?
No, I mean, if you think that's good, that's good. So let's go on to the second one. The legitimate pre-existing agreement. I think we talked about that.
So that was very common, still very common, where you say, hey, you tell your broker, if the stock falls below a particular rate or it goes above a different rate, you have a buy or a sell, right? So
just like a put option or a call option.
Yeah, absolutely. It's very similar. This happens to be for most brokers have this type of agreement. That way they're not constantly on the phone with their clients. In this case, the call itself may have been the triggering event. Why did he call her if it was already there? Right.
Yeah.
So that may have thrown the shade that was needed to get the obstruction charge in. Whether it was or not is irrelevant. She did have a pre-existing agreement to sell. So that's really the key factor here. I don't think that her decision was relevant regardless by her getting the phone call since it was already there. So that would have been one of the key factors, I think, in the defense's motion.
Okay.
And that piece of it's really, really ridiculous to me. And every time we bring it up, it just hits harder and harder because like if anyone watching this trades, like you understand there's something that you can choose and whatever little broker app that you're trading on, there's a specific piece that you can click on. It's called the stop loss that I think a lot of people do, if not everybody has used that one time or another. And it's like, what differentiates a stop loss on one of these apps versus what a pre-existing agreement that was essentially a stop loss on her end for the sell of these shares? It's mind-boggling to me.
Totally
back
agree.
then, the trading software was, not a lot of people use trading software. So that's how you did stop losses, was you actually had a broker and you said, hey, look, if it hits this price, then sell it.
Yeah. Right. And they relied specifically on the broker's knowledge. I would not say that because she was a mogul in Martha Stewart Living omni-channel or whatever it was called at the time, she was very smart, but she was not a broker. So you should be able to rely on that broker's experience. I mean, back in the day, there was commercials that you guys probably wouldn't recall, but there was I dated a broker at one time from E.F. Hutton, and E.F. Hutton would say they had these commercials, and it said when E.F. Hutton talks, people listen. Mm-hmm. Well, honestly, I mean, this was well known. Brokers give you advice, you follow their advice, and on top of that, to your point, both of you, this was a stop loss. It was already in place. Using that as the stick to beat Martha Stewart as a piñata was not really cool. I don't. And so it was just one of the most unfair things that could have happened because she was this juggernaut out in the world and she was constantly in the news. And man, everything's great until you hit that top of the line and then somebody's going to try and drag you down. And that's what happened here. And so using the defenses, especially affirmative defenses here, and those are the ones that we talked about, the four things that I brought up. The biggest two, I think, that Atticus could help with, based on the summary, would be the absence of intent and the fact that she followed counsel's advice and she's being penalized by a lawyer's advice. And that's very, very troubling to me.
One of the things that is really interesting is when people are in the public eye, how prosecutors deal with it. Maybe in a later episode, I don't know if you've watched Tiger King on Netflix, Mark. Maybe we should go over. You have? Okay, well, that might be an interesting one to do next because
it would be. Now,
In
if we
that
could bring it,
case,
that would be a good one.
one person went to jail, but so many people clearly committed crimes. So then it just begs the question, why? Why, what is this decision and where is the fairness involved? But let's get back to Martha Stewart. Let's look at your third argument, which was the lack of material misrepresentation.
So in this case, the defense argued that Stewart didn't make any false statements. There was that were material to the investigation surrounding the M-clone dump. I mean, let's face it, that's what everyone in M-clone did, is they dumped their stock to avoid loss, right? Which is clearly they were insider traders. They were there and they dumped it knowing the FDA was not going to approve it. So where was the misrepresentation that led to the obstruction of justice? It's just lacking here. And so it shouldn't have constituted any sort of fraud. It shouldn't have constituted any obstruction of justice. But yet her celebrity brought it to the fact that the prosecution kept telling everyone in the world, she's lying, she's lying. There's more to know here. Mm-hmm. And it's just, that's part of the insanity of this case, truly.
Yeah. Okay.
Then, that goes again, these dovetail into each other to the absence of intent. Where is the intent? She is on a plane. I mean, of course, she could afford to get a phone call on a plane. I guess that was a big deal because, celebrity status or being.
Yeah, back then smartphones weren't everywhere like they are now.
Well, I mean, there were no such thing as a smartphone really until 2007?
Yeah, 2007 is when the iPhone came out.
So you're talking December of 2001. So we had just gone through, the 1999 problem with, the computer rollover on dates. The world was going to end.
The Y2K
rolls around. Everybody's recovering from that because they have these computers that were, going to fail, not going to fail. We get through that, and then she gets a phone call on a plane. It's just insane. It just drives me absolutely crazy.
So just to explain what
we had a cell phone very early. I had a bag phone where you took the antenna out and you put it on top of your vehicle, and you hope that everything worked well, right? So
just to explain what we're doing here is we're actually gonna have Atticus draft an entire motion. So we selected one of Atticus's recommendations, but the attorney's input is really critical. Somebody that knows the case, somebody that's an expert. That's how Atticus gets guided to know what the best arguments are to make. So we're going ahead and putting in Mark's arguments to help guide Atticus on what to do next. So the next one was absent of scienter, which was intent to deceive. Did I pronounce that correctly?
You did.
You want to talk about this a little bit?
Yeah, this is intent is key, as you know, for any criminal situation, right? I don't care if you're looking at a murder case or whatever the case may be. And in this case, where was the intent to defraud?
Yeah.
They may have said she was obstructing justice based on her counsel's advice, but she had no intent. And the losses were so small. It just seems ludicrous to me that this would have been dismissed by the court and dismissed by the jury because it's such a strong argument. So I think this is part of the filing that I think is crucial. It was filed as part of the case, and let's see what happens here.
So we also had no obstruction of justice. So I didn't realize they actually had charged her with the obstruction of justice. So that's because her testimony, she followed her lawyer's advice, and she said that she didn't recall.
Correct.
Okay.
That's absolutely correct. And that's really ultimately where the lying out in the public eye all the time got her, was that obstruction of justice charge, which got her sent to federal work camp, which was completely miserable, as I understand it. They call it Camp Cupcake, but we'll talk about that later.
Yeah, Camp
It was ridiculous.
Yeah, everything about
the part about it is that she made friends there. We can talk about that later on, but we'll just don't let me forget, because she made cupcakes out of Camp Cupcake, if you can believe that. I can't imagine what it was like for her, having had to go into prisons myself and being patted down. And I think we all talked about this before, but we can talk about that after we get through the generation of the motion here.
Well, let's talk about your experience, and then we can cycle back to Martha Stewart's experience. What was it like going, because you were a defense attorney when you started out, I believe, right?
Yeah, it's that was not where I was headed, obviously, because I I had a biochemistry degree, so I was headed into IP and technology from the start. So
Mhm.
when I was in college, I was working as a programmer to help pay my bills in college, et cetera. So that was always my bet, was to head into technology. At the time, biochemists weren't making anything, and later on, I mean, cancer drugs and everything else had a
Yeah.
lot to do with that sort of thing. So that's just an aside. So what I ended up doing was taking a few criminal contracts to sort of segue while I was studying for the patent bar.
Mhm.
In doing so, I took a federal contract to do 1983 claims. These are the types of claims that um, jailhouse lawyers people see all the time, where they go in and they go, I'm in jail for life, so I need
Yeah.
something to make my life better. Because let me tell you, going to jail
So it's a
is
hope thing for a lot of them.
It is. So when you go in to meet with these people who are in prison for life, you are treated very much like someone who's being in intake for going into the prison. So you take your belt off, you take your shoes off, they look through your briefcase, they make sure that you don't have any contraband. You get patted down in the same way as any prisoner, and then you're taken to, and I'm highly claustrophobic, you get taken to a very, very small attorney room where you're locked in with, in this case, the defendant or the incarcerated person that you're meeting with on a federal claim. And
Yeah.
so I can't imagine the fear that one would have in going into this sort of unknown. And I've seen it happen. And I stopped doing this after one of my clients was, uh, there were 30 counts brought against this particular client, and got all of them dismissed except one, and he went to jail for life.
Wow.
It's very, very,
And after all the other charges were dismissed, just one of them, and he got a life sentence.
yeah, that's correct. And so, without giving any details on that case, it was truly injustice. And for me, I had to step away from doing that. It made me sick at my stomach. In a similar fashion, the way that this case unfolded in the press, in the public eye, this woman who should be lauded for her successes, a true American success story, was
Mhm.
brought down by capriciousness, I think.
Yeah.
So, yeah, I can't imagine what it was like for her when she was getting ready to have to go and serve this time at this quote Camp Cupcake, which it was not at all. So I think TV paints a portrait of these federal uh, prisons as what are some of the ways that they do it? It's help me out here. You know, it's good. It's easy to do.
Mhm.
Come on, what's the term? Forgive me. I'm completely spacing on it. It's like a recreation area instead of actually being a prison. That's just not the case in most cases.
Especially with celebrities too. They always try to, even just like the media, they always try to paint this picture like they're going away for a long time, but it's going to be a comfortable stay away from home.
Exactly.
It's like, especially
Exactly.
with celebrities, it's crazy to
The
me how,
country club. That's what I was trying to get at. They're just
yeah.
going to a country club. They're going to do that, and TV portrays it that way. I've never been to a prison that was a country club when I had to defend anyone. So
Yeah, I can't imagine that they would want to incentivize people to go to jail by making it comfortable.
no, not at all.
That wouldn't make any sense. So we've got two more arguments. The next one is lack of financial motive. We talked about this a little bit.
Yeah, I mean, compared to everyone else, when you had that wiki page up, I think that was very telling. You're talking about millions of shares of stocks being dumped versus hers, which were, I think, valued, if I read that correctly, at $230,000.
Mhm.
Her sustained loss would have been approximately just under $46,000. That makes no sense to me.
Yeah, it
The
doesn't make sense for
justice
someone.
there alone is almost insane.
Yeah, to risk her freedom and everything for someone who's a billionaire for that little money just makes absolutely no sense.
Absolutely.
Okay. Let's look at the last argument, which is good faith and character evidence. I don't think we've talked too much about that, just a little bit.
We haven't, and that goes to what you saw in the case summary. You recall that this Douglas Fanuel, he was a prosecution witness that painted her as sort of the ogre who was very demanding, and she had, I think there was a color of that she was in full knowledge of every one of her trades. That's just the type of person she was. There was no way that she couldn't have known this. And
Mhm.
so what you're talking about is when you are presenting a defense, you have to sort of have character witnesses, and this is something they portray on TV all the time.
Yeah.
If you are a public person like Martha Stewart is, and you have been painted as this sort of witch in the background who is very demanding, that can play against you. And so there was evidence that was presented at trial that should perhaps have been countered well with their own character evidence, the defense's character evidence. I don't know that it would have overcome any of the defense witnesses, one of which was the woman who was on the plane when she took the call. And then they discussed it separately, and that was pretty damning based on her portrayal of Martha Stewart. So that didn't help. And I think the final nail was what this Douglas Daniels had presented. So I think this is something that would have been quality to help her, especially when the intent to commit the fraud or to obstruct justice would have been more strongly and more resonant with the courts.
Yeah.
And with
Definitely.
this Douglas Fanul guy as well, him being kind of like their lead witness on the prosecution side, he was the broker's assistant, Peter's assistant, and basically all he did was go up and say that that Peter told him that they were selling those shares for some kind of like tax loss purpose, I think was the way that they framed it. But if we think about it, the Douglas Fanul guy should have also been in trouble as well, because he was paid off to not say anything. And at the end of this, he just paid a $2,000 fine, and they didn't recommend any jail time because they thought what he had to say was enough to help push the prosecution. Yeah. Get the conviction secured. So
basically, he cut a deal to be a prosecution witness, and they gave him more than a sweetheart deal. He technically, and this is again all my opinion, he's the one that should have gone to jail for a lot longer than Martha Stewart going to jail. It's again, when you look back at this and being kind of a Monday morning quarterback on this whole thing, it's just this was a total miscarriage of justice, just ridiculous. But hey, I guess you had sort of outlined that, Ali, when you talked about how prosecutors move ahead. Now, let's face it, he went ahead and had quite a career after.
The idea that you can get somebody that you know is guilty and let them off the hook so that you can get somebody else to plead guilty or put them under the prison, that never really sat right with me. Justice is justice. It shouldn't be predicated based off of, this person took a deal and this person didn't take a deal. Maybe the entire idea of a plea deal is something that is problematic. Maybe we should be forcing everything to go to court. I don't know.
Like it's tough because it costs a lot of money, and we've seen that too.
I think that it would make prosecutors really think carefully before they charge somebody. Because I think right now
I want to believe that's absolutely true. I want to.
I think it's something like 93% of people take a plea deal that's guilty. So the trials are very rare. Some judges go many years without even running a trial. So let's go ahead and just run the motion. So Atticus also gives us case citations. He can give anywhere from 3 to 20 citations. We'll see those affixed to the end of the motion. We'll go ahead and let it run. It normally takes a couple minutes. So let's open up the motion. Let's take a look at it with some of Mark's arguments. Oop, there we go. So here we've got a motion to dismiss for failure to state an offense. Defendant Martha Stewart, by and through undersigned counsel, in this case, Mr. Mark Underwood, JD, I think that's right.
Yeah.
Respectfully moves this honorable court, pursuant to the rules of criminal procedure 7C1 and 12B3BV, for an order dismissing counts 5 and 6 of the indictment for failure to state an offense. Introduction. Counts 5 and 6 of the indictment charge defendant with securities fraud and obstruction of justice. However, these counts are deficient because they, number one, fail to specify the manner in which the defendant's statements were false. 2, are impermissibly vague and indefinite, preventing the defendant from identifying which statements or portions thereof are allegedly false. And 3, violate the rule against duplicity by alleging more than a single offense within each count. So what's the legal standard? Under Federal Criminal Procedure 7C1, an indictment must contain a plain, concise, and definite written statement of the essential facts constituting the offense charged. An indictment that lacks specificity fails to provide adequate notice to the defendant and is subject to dismissal. Federal Criminal Rule of Procedure 12B3BV permits the defendant to file a motion alleging defect in indictment, including failure to state an offense. So what's the argument? Argument A, absence of insider trading charge weakens the fraud allegation. The prosecutor's decision not to charge Ms. Stewart with insider trading suggests a lack of evidence of possession or use of material non-public information during her stock sale. Without this foundational element, the securities fraud charge lacks a critical underpinning undermining the alleged fraudulent intent necessary to substantiate the charge. B, legitimate pre-existing agreement and lack of material misrepresentation. Ms. Stewart's sale of in-clone shares, let me just get the laser pointer, was pursuant to a pre-existing agreement with her broker to sell stock if its price fell below $60 a share. That's a stop loss, which is crazy. This agreement existed prior to the events in question and was well documented, forming part of her standard investment strategy. Consequently, this transaction reflects no irregular or misleading activity, negating any allegation of material misrepresentation. The defense is prepared to provide evidential support, including brokerage records and witness testimonies to corroborate this agreement. C, absent of scienter, intent to deceive. A key component of the securities fraud charge is scienter, or the intent to deceive, manipulate, or defraud. Ms. Stewart's actions aligned with her established financial practices and lacked fraudulent intent. Her decision to sell was driven by the pre-existing agreement and prevailing market conditions, not deceitful motives. This nullifies the necessary intent element required for the charge. D, alleged obstruction of justice and misunderstandings. The obstruction charge stems from purported inconsistencies during the investigation. However, any discrepancies arose from genuine memory lapses or misunderstandings rather than deliberate attempts to impede justice. Further, Ms. Stewart's extensive cooperation with investigators illustrates a consistent willingness to facilitate, not hinder, the inquiry process. E, consistent reliance on legal counsel. Throughout the investigation, Ms. Stewart sought and followed her legal counsel. Her compliance with legal advice indicates an intention to abide by legal norms and cooperate fully with authorities, countering any allegations of obstruction or intentional wrongdoing. F, lack of financial motive undermines fraud theory. G, good faith and character evidence, and then the conclusion. And then at the end, we have citations for relevant cases that an attorney might want to take a look at and investigate to support these claims. So, Mark, I want to ask you a couple of questions. Number one, how big is it that we have software that can do a draft like this, sometimes in 60 seconds and almost always in less than 5 minutes? That's question number two. And then question number one. And then question number two is, how would you as an attorney use something like this to draft and start preparing a brief that you'd actually file in court?
I think let's take number two first. I think the way that any attorney will look at how to draft motions is key, and then looking at the potential arguments and the case citations is very key as well. So I can have a theory for the case, but what is helpful is looking at an actual draft of the motion so that I can then go through it and say, yeah, this follows what I think my theory would have been, and it's going to save me an incredible amount of time. And that way I can go back, I can do the quick research, I can hand it off to an assistant, have them confirm the case law is actually credible and necessary for the arguments that came up, and then assess the arguments based on this output. I think that's absolutely key. Then if you don't mind, repeat your first question, because I think the second was more relevant to the way that I work and would work as a defense attorney in this particular case.
So the first question was, how big is it of an accomplishment that the software can produce a draft like this? And then the second question is, how would you as an attorney use a draft like this to prepare a brief that you would file in court?
I think I answered the second part of your first question with my discussion points on how this is very relevant in how I would formulate, how I would approach the judge in the case, as well as crafting a quality motion based on the indictment. Going back to the first part of this is huge because in most cases, it would take me a very long time to do the research. Now, some of the tools that are out in the world for legal tech are helping along these lines, but they don't have an overarching case management value here. And so when I'm starting a case, I have to think about first steps, next steps, and the overall roadmap. And this helps me with my roadmap because it starts me off on a very sound footing and timing. I'm trying to save time so that I can prepare my oral arguments that are going to support these written documents that we have to submit to the court. Hopefully that helps you and everyone who's watching this.
Yeah, that makes a lot of sense. You're able to get these drafts extremely fast that help you organize your thoughts and prepare your arguments. And then now what you can do is focus on the more detailed argumentation and the legal and case citation research that the case is actually going to hang on. And then here you can also go to Atticus and craft interrogatories or prepare witnesses or develop trial strategies. So we see that Atticus is really providing a comprehensive war room informational dashboard that an attorney can use to make the best decisions much quicker and then do what someone like Mark does best, which is that deep, nuanced legal thinking. Cases, the success of a legal case isn't going to hinge on some minor formatting or some routine venue question. It's always the really deep, difficult evidentiary or legal precedent or argumentation stuff. But when you're so bogged down doing that routine stuff, then you as an attorney, you don't get to put forward the arguments as rigorously as you could if whereas if you had something like Atticus, now someone like Mark can be like, okay, I've got this draft. This is a great start. This gets me 25% of the way there, or 30% of the way there, or 40% of the way there. And then now Mark can go and really knock it out of the park by finding the best research, the best citations, and making the best arguments, having this as a starting point. So,
Absolutely agree with that.
how do you think, had Martha Stewart's attorneys had access to Atticus, or if you were Martha Stewart's attorney at the time with Atticus, how do you think you might have been able to litigate the case in a way to possibly have gotten her a better outcome? Maybe not have gotten her off the case, but at least something a little bit better than what she did get.
Well, I think what everyone has to realize is the amount of paper that you have to go through when you have these sorts of filings. So an indictment is followed from the prosecution with all of their legal arguments, all of their precedents, and it's all on paper. So you have to do intake of all of that. You have to read all of that. You have to take that into consideration. At the start of the case, my thought process is, here's what the face of the document says before I look at anything else and say, how would I immediately craft this? And so by plugging in the thought process and getting a motion as the starting point, then going back and doing that saves an incredible amount of time. Now, I can't Monday morning quarterback what the defense did in this case, but what I can say is this would have helped them very much in the management of the case moving forward. The time that this took to litigate this case was nearly ridiculous. So if it would have helped streamline that,
Yeah, each one of these doc entries is a document that somebody had to read,
absolutely,
which Atticus takes and in about less than a couple minutes digests the entire thing.
And imagine the time savings that has, because as an attorney, you have so many other things that you have to think about. You have to do client management, you have to do meeting management, you have to do communication management, all of those things. It doesn't matter if you have a whole staff around you, that still takes an incredible amount of time. And in order to streamline that process and the entire litigation process itself, this is not just a great starting point, but it's a management tool as well. And that way I can follow my roadmap to a better outcome. Would it have changed the outcome? Not necessarily, simply because of the public perception and the pressure that was on the defense in this case for the outcome. But I think the tool itself would have helped them with a framework that better prepared them for the arguments that they could have presented in a more, if not timely, but a more concise and direct method.
So what ended up happening to Martha Stewart?
Say that again?
What ended up happening to Martha Stewart?
Well, she ended up being convicted of obstruction of justice and went to Camp Cupcake, which we discussed briefly earlier, which was ridiculous because imagine someone who's used to what she was used to. It was quite an incredible experience. I can't imagine what she must have been thinking. They alluded to it to a degree in the documentary, but being in a dormitory with other convicted felons, because this was a felony conviction, the outcome of which meant that she could no longer be a CEO of her company. It basically destroyed everything that she had built over the course of her lifetime. she's been resilient, as we all know. She's still a public figure, but she would never recover the huge amount of losses that she had. And frankly, she made the best of it because she was able to help those people that she was incarcerated with over that time and you can, it's out there, you can follow it, how she helped some of those people while she was incarcerated be more able to lead lives, not just as quote homemakers, which she was well known for, but some of the skill sets that she passed along while she was there. It was really quite inspiring. But she was really, I think she was railroaded. That's the bottom line from my perspective. I think her defense did a great job, the best job that they could under the immense scrutiny of the case, particularly. But you can see it's an incredible place that she was packed off to, and it was.
That's an interesting way to describe it. Incredible. I'm sure that she probably had some other choice words about it.
I'm quite certain that she did. She was very reserved in the documentary. I can't imagine what she must have been feeling. It was terrible.
Well, my final thoughts are that we live in a time where we have amazing tools, and Atticus is one of those tools. It really is a game changer for litigators. It is a time saver. It is something that can help you see where your blind spots are, develop really strong plans about what to do next, go so far as to draft entire briefs for you, summarize individual documents, summarize the entire case, help you with your interrogatories. We have something incredibly powerful here that can really be a game changer and that could possibly help other people that are accused, like Martha Stewart. Mark, Dakota, any final thoughts before we sign off?
Yeah, I agree with what you said, Ali. I think this has been quite a cool walkthrough of how technology has come forward that will benefit defense teams as they move forward in helping not just with time savings and cost savings, but assuaging some of the challenges that defendants themselves are facing. It's quite an incredible tool, and we live in quite an incredible time. I think this would have helped Martha Stewart, at least to some degree, even based with the public scrutiny that she was on.
Dakota, any thoughts before we sign off?
Yeah, I agree with you guys both. Obviously, I think this kind of software, the technology, just the streamlined workflows that it presents, summed up to the best degree, is exactly what you said, Ali. It's a complete game changer. But even outside of that, I think this was a pretty fun episode, and I'm excited to see how Atticus takes on other high-profile cases that we might review in the future. So if anybody ever has a specific case that you would like to see Atticus review, make sure to let us know. We'd be more than happy to cover it on one of our next episodes.
And with that, thank you for listening and watching the first episode of Atticus Defends, and we hope to see you guys soon.